And former NRA President David Keene says the Second Amendment case being decided by the Supreme Court will have national implications. Here's One America's John Hines.
There is this Supreme Court case, promises to be something of a seminal case, I gather, over the issue of being able to bear arms outside your home. This New York State Rifle and Pistol Association being taken on in the Supreme Court. I wonder if you could offer maybe a prediction about how you think this may play out.
Well, the oral arguments took place recently, and all the reports from the oral arguments in terms of the questions asked by the various justices would seem to indicate that there's a majority that's likely to find for the New York State Rifle and Pistol Association on the question of the right to bear arms as opposed to just the question of the right to keep arms. That would have a tremendous impact both nationally and on the 6, 7, or 8 states that now have what we call may issue concealed carry laws, where the politicians have to decide whether you should be able to carry a firearm or not. It's the most significant case since the Heller and McDonald cases in 2008 and 2010. And it would alter the landscape in very serious ways.
So what you're saying is that this case before the Supreme Court, the New York State Rifle and Pistol Association, this could be a seminal case and a favorable case for Second Amendment rights across the country.
Oh, absolutely. If, in fact, the questions asked by the justices are an indicator of how those justices are going to find. The thing about court cases, you don't know
for sure
until the judges vote where they're going to be. But it seems to be that this court has looked far more favorably on the arguments in favor of the Second Amendment in this case than anyone would have expected it to. And the fact is that the loophole, if you will, from the McDonald and the Heller cases of some time ago was that everyone acknowledges that even fundamental rights are subject to what are called reasonable regulation, speech, firearms, etc. But a fundamental right, and the judge and the court in Heller and McDonald pointed out that a fundamental right requires that the courts look at regulations that are proposed by politicians with what they call strict scrutiny. And the lower courts have not done that. So thus today, for example, in some states, circuit courts have ruled that the AR-15 can be banned because they don't look at the ban with that through that lens. Other jurisdictions and other circuits have said you can't ban it. The court specifically said you can't ban legally owned firearms that are lawfully possessed by a lot of people and used for legal purposes because they look at it with strict scrutiny. So this case, not just because of the merits and the individual issues that are being considered, but with the fact that now we have a court that is very likely, one way or the other, to look back and say to the lower courts, you know, this court, the Supreme Court, said years ago that the right to keep and bear arms, in that case the right to keep arms, for self-defense purposes, is a fundamental right. And a fundamental right makes one look differently at regulations than does something that's not a fundamental right. So this is, since the Heller and McDonald decision, this is the single most important Second Amendment case to come before the Supreme Court.
Dave Keene, editor-at-large of the Washington Times and former president of the National Rifle Association. Thank you for talking to us on One America.
My pleasure.
Want to see more videos like this? Visit OANN.com for immediate access to all the clips you've been waiting to see.